newspaper, and you're going to develop your submissions on the next point, I think.
Thank you. When I started, I said that I was going to go very quickly to what I call the fundamentals of the annulment proceedings, and what I meant here is that we had two limbs for the annulment. That the purported award, that was the one that was delivered according that was stated to be an award by the Alphamix, when in the court below, was a purported award, that it was invalid because in breach of the Article 1026 of the Code of Civil Procedure, given that there was a lack of signature. So this is quite important, and it is important to remind the board that this is not disputed now before the bench, before the board.
Yes.
The second limb was that the signed award, which was filed on the 3rd of the following year, that is 2019, was also null and to no effect because it was outside the mandate of the arbitrator, which mandate had expired on the 31st. At this point, I think it might be of interest to quickly go to the latest extension of the arbitrator's mandate, and I shall be referring your lordships to page 156 of the for that. So at page 136, rather, in fact, we have before the arbitrator 136, my lords, we have, it is style Annex A, we have the sitting of the 3rd of November 18, and there the parties, my learned junior and the opponent, the Mr. Domingue, did make their submissions. And that goes to page 154, and the arbitrator at the end says, would you wish a formal meeting for the award? Both counsels said yes. And Mr. Joseph said, I will inform you when I'm ready. Award is reserved. Then we see at page 69 of the electronic bundle, page 69, that there was an extension, all right? The first extension that was at 68, which was the first extension is at page 68 of the electronic bundle, and it was the extension of the mandate was in writing, in due form, and it was on the 30th of June, and the mandate was to expire on the 30th of November. By consent of the arbitrator and of both parties. And all this was signed by the parties and the arbitrator. Similarly, at page 69, we have that there is a final extension which is dated the 29th of November up to the 31st of December. Now you will remember that on the 5th, the hearing was closed. My friends on both sides had argued the matter before the arbitrator. And in fact, there and then he had up to the 30th, the end of November, to render his award. But it appears that he needed more time, so that he asked for an additional but final extension of the arbitration. The word final is quite telling, my lords. And then we go to the 31st. Subsequently, we can read the sequence that occurred. At page 165, there is an exchange of email between the counsel and the arbitrator. And we see that my friend Mamouji, he writes at the bottom of the page, as both my learned friend Domingue and I have informed you at the latest sitting, we intend to be present when you will give your award. The presence of the parties had also been an important element that the parties had agreed upon. And I hope you will positively entertain my request after the 22nd of December. And therefore, the arbitrator wrote at the top of that page, page 165, that, okay, 27th of December for the award. Then we turn to the following page, 166. On the 21st of December, dear all, writes the arbitrator, I have a predicament on the 27th, has been scheduled. The award will be delivered on the 28th of December at 11 hours precisely in my chambers. Subsequently, on the 26th of December, the following page, 167, it is unlikely that the award will be ready on the 28th. However, with a view to have the matter disposed of within the present mandate, I will deliver it on the 31st, 12 at 10 in my chambers. Sorry for the inconvenience. And then we have extensively this morning gone through what happened on that day, that is when the matter was called at 13:10. Whereby the arbitrator asked for permission to read some parts, the introductory part. It is important, when you look at the sequence, when you look at the pattern, the cursus of what had been agreed, that at the end of the day, and this is quite important, my lords, at the end of that sitting at 13:10 approximately, that contrary to what had happened before, there was no request for an extension of the mandate. There was no request, and there was absolutely, and contrary to what had been agreed and done in the past, there was no writing either. So, I think that it is interesting, and I stated earlier on, in a few words, to look at what the legal framework of an arbitration. An arbitration is contractual. It's an agreement in nature. Article 1008 of the Civil Code, which we can have and read at page 456 of the electronic bundle, and I translate: the arbitration agreement is a contract through which parties to a dispute decide to submit a dispute to arbitration, in other words. And further, at Article 1015 provides that the parties and the arbitrators will, with the procedure, delays and form prescribed by the court, will follow those, unless and if the parties have not agreed otherwise. This is the law. This means, at the end of the day, my lords, that the legal framework for procedure, for extension, for delays, the form, the legal framework is decided by the parties. And it is unless there is no agreement precisely on any particular point that the law will apply. Regarding our case, my lord, in addition to the legal requirement that the award must be signed and communicated to the parties have adopted and agreed upon the following requirements. The award be delivered in the presence of the parties, and the award be filed for it to be a valid final award. I have...
What do you mean by filed?
Filed at the registry of the arbitration tribunal. In this particular case, it was the secretary, because it was a sole arbitrator with a secretary. If we go, and I'll try to, where I noted down the numerous times when, since the beginning of this long arbitration, the award was the cursus all throughout, not only the latest part that I just mentioned. If you give me a few seconds. I will come back to it in a moment, but the fact is, I'd like to bring your attention to the long list of occasions upon which these curses have been followed. And if I may come back to it in a moment, when I'll find it where it is. So, this legal framework means, therefore, that in our case, at the end of the day, there are 3 cumulative elements to be fulfilled for it to be valid. The award has got to be delivered in the presence of the parties. The award has got to be signed. This is the law. And it's fatal if it's not signed. It's not an award. And the award has got to be filed. In the presence of parties, you see that I have, in the latest part of this arbitration, referred to some instances when this was underlined and which form part, therefore, of the agreement of the parties. Now, the law, signature, and filing. Filing, in fact, is what was done in the minutes of the third. But unfortunately, this element, which was an essential requirement that had agreed upon, was done post-expiry date.
Where does the agreement come from? The agreement for filing, that it must be filed?
There was but the decision that it was going to be filed. This is an indication, my lord, when the arbitrator himself said it's going to be filed. Therefore, at the back of his mind, he knew that it had to be filed. And this is at page 170 of the electronic bundle. And I read at page 170. This is on Thursday, the 3rd of January, 2019, at 13:15 hours.
Yeah, but you said that it had been agreed by the parties that in order to be valid, the award must be filed. And I was just wondering where we find that agreement. This is what the arbitrator says he's doing, but where is the agreement which says that this was compulsory?
If you look at page, for instance, at page 61 of the electronic bundle, it is way back on the 30th of July 2016, my lord. Okay? And here we see that after the arbitrator there was some exchange. At this stage, the ruling is filed of record. The filing has always been something which was an element that had to be fulfilled. And when you go to the 3rd of January, at page 170, we can see that the same filing is being done because the arbitrator and the parties knew that it had to be done. And they did it. But the trouble is that they did it after the date of expiry.
But is this... is there an article of the code which says that it's not valid if it isn't filed within the time?
No, there is not an article of the code as such. But when you look at, if I may, at this this minute, which is at page 170, I like to go back to the phraseology used. The arbitrator observes that following the sitting of the 31st of December 18, and with agreement of the parties, a formatted, edited, signed version of the final award is now being filed. The fact that this minute was done is a clear indication, in my humble suggestion, that filing was necessary.
It's also evidence that the parties had agreed that it would be acceptable if the formatted, edited and signed version was filed early in the new year.
But there was no such agreement. As I said, all extension had been clear, unambiguous, and in writing. And there is the statement made by my learned friend on the other side that it was ambiguous. And in fact, my learned friend on the side said it could have been before midnight when the word letter was used. It could have been after. But then she added this morning that, following questioning by your lordship, that within a reasonable time. But why within a reasonable time? Where is it mentioned? Why was it not filed 6 months later?
Well, it may be a bit ambiguous as to exactly when, but what was clear was that it wouldn't be on the 31st of December, and that it would be acceptable for it to be soon afterwards. Maybe if it had got to the 6th of January, there might have been room for argument, but on the next working day, it's clearly within what was understood.
No, but this is not what and it's not our case. Our case is that there was no extension beyond the 31st.
I think my lord is just is putting to you the case as we understand it that is being asserted against you. And we understand your submission in response is that there was no written agreement for an extension in relation to that additional period of time, and the conduct of the parties up to that moment had always involved a written agreement by way of extension.
This is my case, and my case is, our case is that in fact when you look at what I just referred to, and I think I used the word this morning, the arbitrator trying to struggle to comply with the expiry date.
But that may be said to be a point against you, because it was something which occurred on the day. The parties didn't necessarily have time to draw up a separate agreement, and so dealing with the situation in the moment, it is said that the relevant parts were read out, a copy was provided, and it was understood between you that the arbitrator would complete any necessary formal steps as soon as reasonably possible. And that is, as I understand it, what is said against you. And you didn't object at the time.
But I think, in fact, the requirement would have been that there be positive acts on the part of the arbitrator, of the parties themselves, to accept an extension, a tacit prorogation, and which my learned friend has also mixed, and there is a subtle difference which sometimes I can't really make the distinction between...
Well, it may be said it was indeed tacit, because the arbitrator was dealing with the force of circumstances. As you've explained, he was very poorly, and he expressed the need to edit the document, having given the parties the substance of his ruling, and that it would be understood that the formal steps would be completed as soon as reasonably possible. As my Lord has put to you, there was no express agreement. Maybe had it been the 6th, it would have been different, but on the next working day, it is said fell well within the scope of the tacit acceptance by the parties that would be acceptable.
But there need to be more than just... there may be positive acts for it to be clear. As I said, we have brought in Dalloz, for instance, and it is at page 834 of the
834 of the bundle.
No, 843, sorry, 843.
843, thank you.
It must be, and I read it first in French.
Do we have a translation of this part?
We have one which we can provide afterwards. No? Yes, we shall. But if I may,
Which paragraph?
Paragraph 356 and 358. And I read. May I read it in French first?
Well, I think
at least.
I think we can read it in the French, but if you would be kind enough to give us what you understand it in English.
Is that the tacit prorogation must result from positive acts, unequivocal, which shows the volonté, the will of both parties to extend the duration of the arbitration beyond that which had been determined. Like, and they give examples, like participating in expertise operation. It's very clear. Post the expiry date, if obviously you engage into conclusions or submissions, or you bring in witnesses and expertise evidence, then these are very clear positive acts that you have agreed that to a prorogation, to an extension. And this is our fourth proposition, which my learned friend has referred to at page 429 of the electronic bundle, whereby under paragraph 28, it is written, while we were referring to precisely la lose, the répertoire civil, page 429, my lord. Extension 28A, extension may be express or tacit. However, tacit extension is subject to certain conditions. When a party contests that it has tacitly given its consent to extension, the proof cannot be drawn from the observation made by the arbitrators in their award that they have obtained the consent. So it must come from the parties. It's not by the arbitrator himself. A tacit extension, C, will have to result from unequivocal positive acts showing the will of both parties to extend the duration of the arbitration. For instance, when I read it in the French part, at page 843, we could see clearly that there was une opération d'expertise, démarche de renseignement adressée au tribunal arbitral. Okay? You ask, you are very active in your, although the time had expired. And these are it's very, I mean, it's logical that these are pointers to the effect that you have already agreed. And if you read the note 358 rather, further down at page 843, the tacit prorogation must not leave any doubt, any place to doubt regarding the volonté de la prorogation, regarding the desire of the parties to extend. La communication au tribunal des pièces de l'observation après l'expiration du communicate documents to the arbitrator after the expiry date. Well, this is logical. This will show your desire for the extension.
There's two slightly different ways it can be put. One thing is you could have an agreement to extend, and that's what I understand these cases are. But could you not have a different kind of agreement, which is that the arbitrator says, I'm giving you an award now within the time on the 31st of December. It doesn't comply with all the formalities, but do you agree that provided I send you as soon as possible in the new year an award that does comply with the formalities, you won't complain that this award was irregular? Now, would it be possible to have an agreement of that kind?
This is why I say the subtle difference that has been made between waiver and tacit prorogation is something which I have got difficulty to make personally. But for me, it boils down to one thing: whether we agree to an extension or we didn't agree. We can agree in writing, easy. We can agree tacitly, more complicated to analyze. But when it is tacit, it's got to be without any doubt. Positive acts post-expiry are clear pointers. But in our case, when he delivered the purported award, which we say is null, for reasons I'm not going to repeat once more and everyone accept, he said it was going to be given later on. And when we hear even my learned friend agreeing that later on is equivocal, it could have been within the same day, prior to midnight, dismissed, that there is room for a lot of doubt. And it does not, in my humble view, my lord, satisfy the criteria under tacit prorogation. The facts, and I read from subparagraph D, the facts and circumstances on which it is claimed to establish a tacit extension must leave room to no doubt as to the will. No doubt. And clearly, in the own words of my learned friends, there is doubt. And if there is doubt, there cannot be, in law, a tacit reconduction. When I say not reconduction, that's a good thing. A tacit extension or prorogation. And I repeat myself, but the room for that is enormous. According to my friend, it could have been reasonable time after resumption of work. There were 2 public holidays on the 1st and the 2nd, but it could have been. Why not? What if this had happened on the 15th of May 2019? We would have been told there has been a tacit extension. The arbitrator took a lot of time, true, to do this filing and to do the editing and to do the formatting and the signing, but still it's within his province because there was a tacit prorogation. I think this would be stretching it extremely far. Why do I take this extreme example? Is to try to prove my point that there was extreme doubt, and short of something clear. Therefore, in law, I invite the board to find out that there was no tacit reconduction.
Are waiver of irregularity and tacit prorogation one and the same thing, or are they different? There's a decision of the Paris Court of Appeal, which is quoted on page 415 in the appellant's case, which uses both concepts in the same paragraph.
415, yes?
Yeah, in paragraph 7.68, and the original text is in the footnote 61, where they're saying there that after the arbitrator sent a letter saying that he was going to render his decision after the time limit, and there was no objection taken, and it says that the appellant tacitly agreed to the extension, then goes on to say, as the appellant waived the right to rely on this irregularity during the arbitration proceedings, the plea for setting aside is inadmissible. You know, like a slightly separate concept of waiving the irregularity than from agreeing an extension of time. You might simply agree that you won't object that the award is irregular, provided that you get the signed version a day later.
Yes.
That isn't actually agreeing an extension of time, but it's saying, well, I'm not going to take any argument about it.
Thank you, my lord. I get the point, and the distinction is quite clearly made by your lordship. I do agree. But at least this waiver must be clear. But here.
But if it's clear, you would accept that it's a legally valid principle. If it were clear.
Under Mauritian law, is a waiver. I haven't got the answer, because for me, in my head, it was always something which was the two faces of the same coin. So is it possible to distinguish, to say that there can be a waiver of a right? I waive my right to have what I call the purported award, which is invalid. I waive my right to challenge it as being irregular, and therefore the consequence of that waiver would be that when there's no tacit prorogation, I understand, but post the expiry date, when there is this edited, formatted, signed award which is filed, then therefore it is valid.
Must be treated as valid.
Because it was irregular, it was invalid at the time the purported award was made, but I accepted with my right to contest with the validity. This is a way of approaching the problem, but in my humble view, if that had been the case, it had to be extremely clear, which is not our case here. Obviously, we don't know the facts really of this case, which is being referred by Alphamix in the Alphamix Ltd case.
But it's a matter of principle.
It is a question of, I know, it's a question of principle. At this stage, the arbitrator intimates, if I read from page 168, at this stage, the arbitrator intimates to the parties that they will be provided with an unedited version of the award, as it has not yet been formatted, and that an edited version will be provided later on. Assurance is given that there will be no change in substance. But where is the whether on record? There is no whether as far as I see it.
Well then, over the page, both counsels state they have no objection. Now I know you say what they say doesn't matter, but most usually thought that if counsel say they have no objection, that's an indication that the parties are content with that.
Yes, no objection to receive an edited, signed, formatted document within the time frame of the arbitration, within its mandate.
Well, that wouldn't need their consent, would it?
No.
That wouldn't need their consent. That wouldn't require his inquiry as to whether...
He wouldn't need to ask.
It wouldn't.
If he was going to do it that day, he wouldn't need to ask whether they had any problem with it coming later.
In the past, I think it's good that one be reminded that in the past, the arbitrator has corresponded with the counsel and parties. Okay. In the past, he could well have have communicated and sent his final version edited within the expiry date. He was supposed to deliver the award at 10. He was supposed to deliver it before, by the way, but let's say on that date, he was supposed to deliver at 10. 10 asked us to come back at 12. At 12, we were not expecting some draft award. We were expecting a final award. At 10, we've got to wait until 13:06. 13:06, we know the story, and I'm not going to go back onto it. So, and he had also, and this is why I say, it didn't comply with the filing, which, when I say that the legal framework required in our particular case, because of the agreement of the parties, the pattern, the legal framework imposed a filing.
Well, presumably if Mr. Mambaji had said, no, I do object, if the award's going to be valid, it's got to be signed, formatted, etc. today, then the arbitrator would have said, well, all right, then you sit in the waiting room then for the next couple of hours and until I can do it.
Or maybe we'll have asked for an extension, I don't know. But the fact remains that he was in duty to deliver his award on that day. He should have done it before the arbitrator. And he could, because the legitimate expectation we had is that he knew, as I say, he knew that this guillotine date was there. He was struggling, in spite of his ill health, to deliver, to render the award within the time frame. He had a draft award by 2 o'clock. He could certainly have formatted and sent it and signed it within the next few hours. And there are instances where he has communicated to the parties, and they're by email. For instance, at page 165, I just mentioned page 165 earlier on this afternoon, and we see that there are exchanges between the arbitrator and the council. At page 166, there is this from Jacques Marie-Joseph at Gove official address, and then the next page also said we were legitimately expecting that he complied with his mandate, with his mission, and that he gave a valid final award on that particular day, post, and this is what we expected by when he said later on.
Do you accept that the appellants have relied on, for the concept of waiver, they've relied on a case called Ramachwar, that's at paragraph 764, electronic bundle 413, a Mauritius case that came to this board, which at 714 sets out the principle of waiver in the first paragraph. Do you accept that that is a good statement of the law of waiver?
I understand that this is, Rameshwar is an appeal from the motion judiciary.
Yeah.
And therefore it's the dicta of the highest court of our land,
Yeah.
because it's a privy council. Yes? It's a privy council case where they reproduce whether by conduct, the principle of whether is simply this: if one party by its conduct leads another party to believe strict rights arising under the contract will not be insisted upon, etc., he does act on it. But again, the question is whether I accept that this principle of whether is in our law. But this has been the decision of the Privy Council.
Yes, I mean, what it said there is that you wouldn't be allowed to assist on the strict legal rights if they'd been if the waiver had been relied on, when it would be inequitable for him to do so.
If the first party will not afterwards be allowed to insist on the strict legal rights when it would be inequitable for him to do so. Yes, but this had to be, the conduct had to be clear. But here our conduct was not clear that we were waiving anything. But our understanding is later on that it was going to be on the same day. And I do not see anything in our conduct that shows anything positive that shows that we waive our right to contest that the purported award was invalid.
Well, why would you be asking to be sent an unsigned copy if you're expecting the signed copy to come anyway that day?
Good question. Because I think this would be unfolding during the course of the day. They had been waiting since the morning in the chambers or in the proximity of the chambers of the arbitrator. By the time they were in the chambers of the arbitrator, he reads two parts. There is a request that at least we see the full transcript of the award. This was totally justified. But this doesn't mean that we waive our right, or we decided that the edition, the more so that we know that it was just a question of editing, okay? In the modern days, editing You go through it, you read it, and it can be done quite quickly, be it at 3 o'clock, 4 o'clock, 5 o'clock. I mean, there was no reason why it could not have been done. And I like my instructing attorney is suggesting to me, obviously, I mean, and I think it goes in the same way I was trying to expose my thoughts. We all want, when we get a judgment, to know the reasoning of a judge. The decision is there, it's quite a few pages. We all want to read it. We expect to be able to read it. We are eager to be able to read it. But we know it's not going to be changed. But at no point in time do we preclude ourselves, tie our hands and say, okay, just that, and then we're waiving your obligation to fulfill your mandate.
I think the submissions on this particular point are now pretty clear on both sides.
Thank you. Let me, I found my little notes, and for the sake of completeness, I told you that on a number of occasions the pattern had been agreed that it would be in presence, the award. There were several part awards we saw, several part awards in the past, and these part awards were, some of it I've already referred to, at page 60 and 61, where we see that on the 30th of July it was in the presence, the ruling is read in presence of the parties. I just mentioned that. We have it at page 163, and I think I've gone onto this one too, the 163, which is, it was in the Alphamix second affidavit. Yes, I think this is quite important, my lord. In the second affidavit of the representative of Alphamix, okay, at page, yes, Mr. Appellant.
Which page?
163, top of the page.
Thank you.
I agree with paragraph further, and then the second line, very important. It was indeed agreed that the final award would be delivered in the presence of both parties after due notice of date, time and place. This is what has taken place as recorded in documents PA1 to PA5 to this affidavit, and it attaches the different affidavit. So, Alphamix own representative, when the case was being debated, thrashed out before the Supreme Court of Mauritius, state very clearly the agreement in presence of the parties after due notice of date, time and place to them.
But are you saying that wasn't done in this case?
Yes, it was not.
But there hasn't been an objection of yours to date, I don't think.
There was
You haven't so far said the award's invalid or nullity because it wasn't delivered in the presence of the parties, have you? I mean, where do we see that?
But the fact remains, the draft award, which is invalid, was in the presence of the parties, yes. But the signed award was not, and it is not disputed, was not in the presence of the parties.
Right, but where have you raised that as an objection to the validity of the award?
Where did I raise this objection? That
yes.
It was...
Is it in your case? Was it your case before the Supreme Court?
The fact that it wasn't delivered in the presence of the parties as an objection. Are you saying that's an objection? Because we'd understood it was the fact that there was not a signed copy produced on the 31st of December.
On the 31st of December, it was not signed, it was in presence of the parties, it was read and circulated. But in a way, it was read, okay, in presence of parties. But on the 3rd, And this, we have contradicted in our written case, I must find out, the other side, when the other side says something which is, in our view, factually incorrect, that on the 3rd of January, the award, which we know was filed, and then there was a mail, you can come by 2 o'clock on the 3rd of January to come and collect it, but there's absolutely no evidence that we did, that first of all it was done in the presence of the parties, it was not done in the presence of the parties in filing, and there's no evidence even that we did, that the parties went to collect it, contrary to what has been stated somewhere somehow in the written case of Alphamix. And we have...
well, your motion paper in front of the Supreme Court asked for the award to be set aside because it contravened Article 1026(5).
Yes.
And 1026(5) is about the name of the arbitrators, the date of the award, not about presence of the parties.
No, because presence of parties is not a provision of the Civil Code.
No. So
we were saying
when
that
you're
it was...
asking for the award to be set aside because it contravenes Article 1026(5), you are not asking for it to be set aside on the ground that it wasn't delivered in the presence of the parties.
Yes, I did not put this as a ground because for us, a crucial date, expiry date, was enough.
So suppose it were proved that the arbitrator had signed it on the 31st of December, would you accept then that it's a valid award and can't be annulled? Suppose it were proved that the arbitrator did sign it on the 31st of December, would you then accept that it would follow that the award is valid?
No, we would also now be telling the board that there would be, in view of the circumstances, even if it was established that it was signed on the 31st, which is obviously not the case, we would be saying that there were, according to the agreement, there were 2 other essential elements that had not been fulfilled.
And where has that been ever argued before this afternoon? On your behalf.
Yeah.
On your behalf. Has that point been argued before this afternoon?
No, we did not argue it because we thought that we were very strong on the point of expiry of the mission of the arbitrator.
So if you're not doing so well on that point, you'd like to start raising new points here for the first time. Is that what it comes to?
But the term that we can use here is not only the mandate of the arbitrator, but also when you look at the Code Civil, the mission of the arbitrator. And this is also borne out in the, although we don't specifically pinpoint to this aspect, but the Civil Code provides under Article, I must find it out, that failure for him to adjudicate in relation to his mission, and his mission there was this procedural aspect that was embedded in his mission, and therefore this could have been also, this is in fact a point of nullity. And the fact is that we did not put it before the Supreme Court because we didn't thought it was necessary. We thought the point was very strong to go on one point, but now being given that we are before the board and we are going more extensively in all the aspects of the case, we think that this would be a matter for your consideration also. That is, that it had become part and parcel of his mission that he had to render the award in presence and file. And these 2 elements are lacking. Therefore, to answer the point of your lordship as to whether, if it was ever proved that, in fact, between 2 and midnight, 2 o'clock, he did sit, write, put it in his drawer, then these 2 points will be arguing that it was still invalid because of this, it lacks these 2 requirements, had not been fulfilled.
And you say they arise by agreement, not because of anything in the civil code?
Yes.
And is there anything in the civil code which says that if an agreed procedural formality is not complied with, the award will be null?
I don't think that it says it specifically, I guess. But the mission of the arbitrator, the mandate, the mission of the arbitrator is, as I stated earlier on, something which is governed by the agreement, the arbitral agreement, le compromis d'arbitrage. So if
Well, where is that, or was that a rolling agreement? I mean, was that set out in an arbitration clause or a written arbitration agreement?
I don't know if we have the terms of the terms of reference of the arbitrator. We have partly it, because in his award, I think he recaps his award. He recaps the terms of the issues, the terms on which he had to adjudicate, and in the first part of his adjudication. But the term of reference, yes, page 52 and 53 of the Kiban. He had, there was a few issues left. Remembering that this arbitration, there was an history behind it, but there were some issues left, 4 items. And then when we go to the award itself, where we shall see that in his award, he goes quite extensively recapping on how each and every issue were dealt.
Well, is that not the arbitrator's mission, this document?
Yes, it is a mission.
It doesn't say anything about filing or awards in the presence of the parties. The mission which has been conferred upon him, to use the language of Article 1027(3), is to determine these issues.
Yes. But it does not mean that, this is why I try to embed it with what had occurred. We know that the sequence, the pattern, the dominant pattern of this very lengthy arbitration was that there were formal meetings. And this is why I was recapping on some of the on the minutes or the transcripts whereby we see that it was done like this in the past. And most importantly, it is when the arbitrator himself, he says, because he knows the pattern, he's been for quite some time, would you wish a formal meeting? Yes, yes.
Where did the time limit come from that then had to be extended?
Let's see.
So that doesn't seem to be mentioned in this document.
Yes. So.
I think that comes from the code, isn't it? 6 months and is in the code.
There's a 6-month time limit in the code, is it? Right.
Yeah, the code says 6 months' time.
Right.
If nothing else is
Article 10,
stipulated.
1015.
Nothing else is stipulated. It's 6 months.
Well, if there's nothing in the code and there's nothing in the terms of reference, then the fact that he may have asked whether you'd like it delivered and they say yes, it doesn't mean that's a matter going to his jurisdiction.
Our contention is that the pattern, the fact that it was always like this, clearly says, and clearly indicates that this was an element which he had to fulfill. At page 54 and 55 of the key bundle, both parties jointly agreed on the mandate of the arbitrator. And if you look at all the if you, maybe for the sake of being complete here, when we go to all the extensions that I can look at, please refer to page 54, where we have, at page 54, 55, okay? At this stage, both parties jointly agree that the mandate of the arbitrator be extended to the 31st of December 15. Then...
Well, with respect, that is from the 25th of September.
Yes.
Well, they have to agree that, because otherwise, say the code means that his mandate will run out.
Yeah. But it shows again what was done. That at 56, 57, again, Mr. Soku further states that there is a second issue for that the arbitrators, 57, that the arbitrator's mandate in the present matter expires on the December 15, and so it is a joint motion that the said mandate be extended for a further period of 6 months. Again, joint motion. Concur, page 58.
Now, how is that an agreement if it's made by counsel, in view of the fact that you said counsel couldn't bind the client?
I think my learned judge tells me that each time it was embodied in an agreement. And here, for instance, at 92, no, not 92, 59, I got to the wrong pagination at the top, at 58, 59, the arbitral agreement be renewed for a further period of 2 months. Both parties. And at page 63, we've already gone on that. The ruling is file of record. This is one of the indications that it was filed on the record, so the filing was important. There was a joint motion at 63 to renew the mandate of the present arbitrator.
But where, I don't follow where this is getting you, because the circumstances are entirely different. We've got a situation where the parties now know what the award is. It's not as if, oh, in the past we've agreed an extension of 6 months, perhaps we should do that again. It would have been absolutely ludicrous to do the same thing again. So why does it matter what's gone on in the past as regards extending the mandate in circumstances that are completely different?
Circumstances obviously are completely different. However, we have an arbitrator who has got a mandate which is expiring on a particular date, and he has, like in the past, there should have been, if we didn't want things to be ambiguous, equivocal, something clear, either by saying it in so many words, it is extended to the 3rd of January, or by better having an addendum to the arbitration agreement. I think, my lords, I'm very happy for all these remarks, but I think it's very important to underline this aspect, because we believe, and I answer the point of your lordship, we believe that this is a long arbitration. It's not a one-off when we have an extension in writing. Well, it's not a one-off when we have it delivered in the presence of the parties, this part award. It has been systematic all throughout. This systematic sequence clearly points to the effect that this was embodied in the agreement, as I said, not only governed by provisions of the law, but also by agreement of the parties. Clearly, an arbitration is a compromis, it's an arbitral agreement.
I'm conscious we've asked you a lot of questions and time is moving on.
Okay, sorry. And I finish on that. And we can see, we were talking about a record that the extension of the mandate was in writing on page 67, and then on page 68 and 69, where there were 2 extensions of the arbitration agreement.
Yeah.
Clearly, right.
Do you accept the award is made on the date it's signed, even if it's communicated to the parties later, or do you dispute that proposition?
I say that common sense, but no, fact, when the award is made on the day it is signed.
Yes, you agree with that. Well, I know you dispute about when the award was signed, but one of the points raised is that if it's signed on one day and communicated to the parties on the next day, the date it's made is the date it's signed. Is that something you agree with or not?
We say in this particular case there had to be more than that, because as you will see in our second proposition, we suggest that the date of presentation and filing is something which is necessary.
Well, that, you say, is a question of the case law rather than agreement between the parties. Your second proposition depends on the interpretation of what the court decided in that particular case. It's been suggested that your interpretation of that case is wrong, and that you are confusing the submissions which the parties made to the court and the court's own decision. So you will need to deal with that.
I heard what my learned friend said in relation to obviously when I read the case law of the Cour de Cassation, I think the proposition was that the day, what I got from the gist of it was that the date of presentation to the parties was a formality which was of necessity. Now I'm being told that this reading might be wrong, because this was not the dicta, if I may say so, of the Cour de Cassation. Is that what is being suggested here?
That's what was suggested by the appellant, that you have muddled up what the court decided and what the arguments were.
Okay, this is something which, for the sake of today at least, I maintain what I've stated in my second proposition, and I'd like to see whether this was a wrong reading, if that was, because this is what we read as being the gist of this decision.
So you say that what the Cour de Cassation decided in this case was that the date of presentation of the award is the effective date of the award. You rest your case on that proposition of law as decided by the Cour de Cassation. Is that right?
May I have a word with my instructing attorney? Is it possible?
Yes. If you need a moment to take instructions, yes.
I beg your pardon?
Yes, please do take a moment. This may be an important point. Are you able to assist us?
Yes, obviously, if I hadn't the opportunity of listening to my friend this morning, I would have been very adamant about this. But when I relied on this in my written case, which is when the judge of the Supreme Court relied on this in their judgment at page 301.
Page 301.
So there is confusion between the pagination here, and that's page 212. Considérant que le délai conventionnel d'imposition n'a pas été prolongé par accord des parties, en justice espagnole, alors que la sentence est rendue lorsqu'elle est délibérée et présentée aux parties.
Sorry, where are you reading from? The judgment paragraph?
Judgment of the Cour de cassation le 4 mai 2017.
You're reading from the Court of Cassation?
Yes.
Which page is that?
Page 312 of, and this is the court judgment below.
Page 312 of our electronic file, or the...
Yes.
If I can assist, just
Yes, please.
312 is the judgment of the Mauritian Supreme Court, the part
Yes.
where it refers to the 2017 Cour de Cassation case. The Cour de Cassation case itself is at page 775.
Thank you.
Is this correct?
So what the court is, what the Supreme Court is quoting is the submission. Not quoting the judgment, it's quoting the submission. If you go back to page 775, you can see,
775.
you can see that the judges are named about a quarter of the way down the page, Madame Battu and so forth, Monsieur Acquaviva. They have a report from Monsieur Acquaviva. They have observations on behalf of SCP from Spinozzi and Samal, who are the advocates for the appellant, the Société Route de Magny. The court then makes its decision in the paragraph immediately above the words in capitals par ces motifs, which don't include the part quoted by the Supreme Court. And then you get the moyen annexe, which are the submissions made by Spinozzi and Sureau on behalf of the appellant. And that is what that's what the Supreme Court is quoting at page 312 of our bundle. So they're not quoting what the Court of Cassation decided, they're quoting the argument for the unsuccessful appellant.
But maybe I'm not sufficiently familiar, but it appears to me that, I do understand the point that this is a submission being made by one Mr. Spinozzi and Sure, but, and that there is a decision here, but is it a fact that they have rejected, because it has been le pourvoi, the Court of Appeal was, the decision was maintained, as far as I remember.
I think at this stage we'd be grateful for your submission on, in response to the point made by the appellant.
Yes.
It's not a new point. All this was set out in their case before you submitted your case.
Yes. We're talking about the points being made about the primary case. And
The point here about this Cour de Cassation decision, and that what's been relied on is the unsuccessful argument, not the ruling.
What the Court of Cassation seems to have decided was there was a conflict between two dates in the award, the second of which was out of time and suggested that that was when it was signed by the arbitrators. The administrative authority conducting the arbitration confirmed that it had indeed been signed on the 13th of September, and it was for that reason that the award was invalid, because it hadn't been signed in time.
if we go on the assumption that the decision of, as your Lordship has reminded us, the decision is that, and this is only a submission that was made, but we must remember that, as I stated, there were other elements that need to be fulfilled. We don't know the factual background of this case, okay?
But this is the only matter you rely upon to support the proposition. This decision is the only matter you rely upon. That's correct.
And the court below?
No, in your case,
Oh, well.
this Court
Cour de Cassation decision is the only basis for your argument. There's no other legal material that you rely on. All the other material that we've been shown goes the other way.
Yeah.
The commentaries, the decision of the Paris Court of Appeal of 2006.
What we make of this, let's assume that this is the decision, and and that the court, it's not the presentation in relation to this particular case, okay? But in our case, the Supreme Court found that it was signed after the expiry date, that it was rendered, delivered after the expiry date. This was a finding of the Supreme Court. And the point was not raised, and they were had no opportunity to look into it. And when we couple this with any case, in any case, the fact that the signed award, albeit the date being post or prior to the 31st, it had also to be made in presence of the parties. It had also to be filed.
Yes, well, I think we have those additional points.
But I'm trying to answer, my lord, the very, very interesting and pertinent point being made by one of your lordships in relation to this particular case law.
Yes, thank you.
Well, because I've been lengthily going, and I know the time is running, on this question of the tacit recondition waiver and so on. I'll try to finish on this before going to the other points being made in under grounds A, B, D, and G. My friend has stated that she has also embarked on a notion of express judicial contract that she used in the written case, in a written case on behalf of Alphamix, which it was, as I stated in my written case, introduced for the first time. But from a semantic point of view, we are not before the judiciary. We were before an arbitration. So we're talking about an arbitration agreement, un compromis d'arbitrage. And the question remains is whether the parties had agreed to the extension, and this is the famous question that we'll have to answer. And to recap here, there was ambiguity, therefore this cannot be an extension. The reading of paragraph 7.5 of Alphamix written case, in my view, is, and I repeat, is quite striking because it reinforces the understanding of the District Council that the sign award would be delivered later on, and that could be prior, according to what has been considered, to midnight. And it also, in my humble view, contradicts the stand of Alphamix on appeal before the board that the sign award was ready before midnight. I think you cannot have it both ways. Either it was ready or it was signed afterwards. The issue of tacit, so I've already gone very lengthily into it. And I've done on this question of tacit. And given that it was ambiguous, equivoque, as stated by my learned friend, I conclude that this ground, now being canvassed forcefully on appeal, cannot be accepted, and therefore this ground should be dismissed. We have the question of the other grounds of appeal. The other grounds of appeal, in fact, my learned friend also tried to regroup all of them, and it was in relation to this award being made on that particular date. We have gone somewhere, somehow, in it, and I state and repeat that it is common sense that the date appearing on a sign instrument indicates the date of the signature. However, we must look at all the circumstantial evidence in this matter, and this is not an unrebuttable presumption, certainly not. And the matter should have had to be flushed out in the court below to be able to be analyzed and decided upon. And one striking thing is that I think I adumbrated on it earlier on. The person who was most likely to be able to clarify matters was the arbitrator, and he did not do it. My learned friend stated at a stage that the counsel for the arbitrator, the correspondent then before the Supreme Court of Mauritius, did make verbal arguments. But by the time we made the full verbal arguments orally, he was already out. He only made those written submission, which now she is using on appeal. But as I said, all right, the tacit reconduction prorogation issue was in it, and I even addressed it, as I was reminded earlier on this morning, but this was not the case of the Alphamix. Alphamix rests its entire case on two matters. The first matter, the purported award was a good award. And the second matter, you will recall that I had raised an additional issue, which they didn't go into it, this question of compounded interest. And if you look at the length of his argumentation, both in writing and on appeal, you'll see that very little is said in relation to the ground he was supporting, that is, in relation to the fact that there had been a valid award, what we call the purported award, and he wanted to establish that this was a good award, and we know that it was not a good award, and this is now undisputed. So I shall invite the board, in any case, your lordships, to look into the circumstances, and which I think the circumstances cast serious doubt as to whether we can conclude that there was a signature and all the editing and formatting prior to the expiry of the deal, which is the main part of Alphamix. Remembering, one thing is of interest, may we remember that in the draft award, and I'll go quickly, in the draft award, the date was type, 31st. The one that was circulated at 1356. It was type. Now, the final award, signed one, okay, same template, it was type. So, this is not quite incredible that it used the same, on the third, it used the same template. Now, I stress on the word now being filed. I've gone into it at page 170, coupled with the email sent a few minutes later, is to the effect that the formatted, edited, and signed version of the award is ready. And this is now ready. And you can contrast the wording of this email by that one sent on the 3rd of January with the one which had been sent at 1356. Again, it was not ready before. It was now ready on the 3rd of January. We are not going to come back onto the circumstances of the arbitrator's predicaments, but in all probabilities, it is very unlikely that he would have, after 2 p.m. on that very date, go back to work and do his own work. And had he done so, and I appreciated the remark of one of your lordships to the effect that, why on earth did he not circulate a copy? We know that he had been emailing the parties on some occasions before. Page 165, 166, and 167.
Well, now I think you're coming to the end of your time, so if there are submissions that you feel you need to make to wrap up, we would be very grateful.
Yes.
Particular question. Conscious we have asked you a lot of questions, so I don't want to prevent you from summarising any particular points you'd like to draw to our attention, but I think we must urge you to complete your submissions now as quickly as you possibly can.
Yes. What is ground D about? Ground D is that there
This is
is
the
no
purported award
evidence.
being signed on that day.
Exactly.
Yeah.
Okay. And they say that the learned judge erred on that. But if you look at the judgment itself at page 319, how can we say 319, how can we say that there was an error? And I'll quickly go on it. 319. I always mix with pages. Yes. This is what is embodied in the ground. But the Supreme Court at page 185, the Supreme Court at page 185, what did they write? They wrote, no.
I think you want page 311.
Well, exactly, thank you, my lord. What they're saying that we have considered the rubbish DVD draft award which is referred to and did not in fact deliver a valid award duly signed upon which they could probably act upon. Okay? What the arbitrator was referring here, and this is why I say there can not be an error, we were not referring to the final signed award. They were referring to the purported award. Okay? And now they were referring to a draft award, and not to the point now being trying that where they are conversing on appeal underground A also, that the signed award was delivered on the 3rd, 1/19 had been made in fact on the 31st. They were not considering that. They were saying these remarks, which she extracted from the judgment in relation to the draft award. That was similar when you look at ground D of the ground of appeal itself. Also, it is interesting in relation to ground D that it is undisputed now that in own words of Mr. Appellant for Alphamix, that the award circulated at 1366 on the 31st was a valid award. So all for them, always the valid award was at 1366. So these remarks of the learned judge on appeal are in relation to the draft award. There was no question in their mind in relation to the signed award that was filed on the 31st, on the 3rd rather.
Yeah.
Ground B, when we look at ground B at page 31, the learned judge erred by relying on the grounds of a party to the Court of Cassation. All right. This is the ground we've been talking about all throughout.
We've been around all the grounds several times by now.
We have indeed, my lord.
I think I really must encourage you to wrap up now. You've overrun by quite a considerable time.
And lastly, in those 3 grounds that was regrouped,
Yes.
they deal with the ground G deals with the same point as I understand it as ground A, which I've already dealt with. So, being given, and this maybe should be the approach, and I'll end on this, being given that at no point in time was it contended before the court below that the award had been signed on the 31st, there was never any mention or contention, and that the case of Alphamix had always been that the purported award was the valid award. Therefore, all these challenges where the grounds of appeal finds fault with the reasoning of the judge of the Supreme Court are not legitimate and justified. And the last point, and I'll end on that, it's a very tiny little point, but I learned my friend saying that we should, when she pleaded, my friend Anne-Sophie Julien, on the equitable aspect that should have been used, and so on and so forth. I'll just like to, the civil code provisions, we all know that every contract must be entered into good faith. This is one thing. Equity does not go in. And for an arbitration, for an arbitrator to now get into equitable remedies or aspects, he must be appointed as an amiable compositor, which is not the case here. So all the argumentation made in relation to that there was equity allowed and the arbitrator to do so, this is not correct in my humble view, being given that he was a normal arbitrator, not an amiable compositor, and I've done, and thank you for allowing me to.
We're very grateful. Thank you very much. Yes, now, submissions strictly in reply.
My Lord, strictly in reply, but may I just correct one thing, first of all, which I said in my submissions before?
Of course.
I think I was asked by one of your lordships whether our grounds for appeal were the ones that are in paragraph 17 of the written case of Respondent, and I said they were. I made a slight mistake because there is actually one other ground, which is ground B in the original set of grounds, in other words, the ones set out in paragraph 16 of that written case. That is the one simply which says that the 2017 Cour de Cassation case was misinterpreted. Of course, we have not dropped that, and so I should not have said that our only grounds of appeal were the ones in paragraph 17. They're actually also in they also include ground B in paragraph 16. I hope that I haven't made it even more confusing than the way I've just explained it, but and I said 17 and 16, and I meant 7 and 6. Apologies for that. With that, if I might turn to reply to some of the points, and then my learned friend Ms. Julien will reply to others, obviously, depending on which of the issues have been raised. First of all, in relation to the two rules of French law, therefore incorporated into Mauritian law, which I submitted to your lordships this morning, what you have heard from my learned friend is an agreement in relation to the presumption. Remember, he described it as common sense, and then when he was pressed in it, he was...
Yes, we've got that point, thank you.
And secondly, but it's the consequence of what I'm about to say, and secondly, very little resistance in relation to the interpretation of the 2017 Cour de Cassation case, and therefore very little resistance in relation to the point that the date of signature is the date of rendering. The consequence which I would submit to your lordships is that means that those 2 points, those 2 rules, are effectively indisputably correct. One has not been disputed and the other has hardly been disputed. And that therefore, my lords, they fall within the exception to the rule against new points set out by the board in the Gruel's case, and I don't have time to take your lordships to it, but the reference in the electronic bundle is page 635, and it's paragraph 26 of that judgment. Second point in reply is that, as you remember, my learned friend effectively gave evidence that the arbitrator would never have signed the award on the 31st of December 2018. And what we would say, but obviously your lordships already have it, is that he simply can't do that. And even if he has next to him Mr. Mamouji, who was indeed there, it's simply inappropriate for counsel to be giving evidence on that. And therefore, all that he's done is to speculate, and we counter-speculated, and who knows who is correct about this. And that is, of course, my lords, why the presumption is so important, and we rest upon that presumption. Third point in reply is that my learned friend said that he had given the arbitrator a chance to explain what had happened by putting him in cause in the proceedings before the Mauritian Supreme Court. And he said that the co-arbitrator had basically declined that opportunity. But in fact, my lords, he did provide an explanation, or a sufficient explanation, and that is, of course, what your lordships will find at page 195 of the electronic bundle. That's paragraph 26 of the written submissions of the arbitrator, the co-respondent, before the Mauritian Supreme Court. You've been taken to it already a number of times, but he does say, or his counsel says very clearly, the last page of the award shows that the award was signed on the 31st of December 2018. And we would submit that that is...
Well, that can't be treated as evidence, can it?
No, it's not evidence, but it is an explanation. And it's an explanation...
It's capable of being read as simply saying that that's what appears on the face of the award without asserting that it was, in fact, signed on that day.
Well, presumably, I won't press this too much, but just to say that presumably the arbitrator read these submissions before they were put in, saw this explanation, and presumably if he had known that this was actually a misleading explanation, which it would have been if it wasn't true, he would have said that. But I don't push it any further than that, my lord. Then just two more points, if I may. First of all, in relation to the three conditions that Leonard Friend made submissions on, and there was much discussion, and therefore I won't go back into it in too much detail, but just to be clear about what our position is on that. First of all, we do not agree that those three conditions were agreed to between the parties, and I'm not going to take your lordships back to the various documents about that, but nowhere in there does it say at any point that the delivery or the filing was required, and the signature, of course, was in any case a requirement of domestic arbitration law. But in any case, the three conditions were actually satisfied, my lords, and they were satisfied because, of course, on the 31st of December 2018, the award was delivered in a formal way at that meeting at 1:10 p.m. And it was, in our submission, signed because it is presumed to have been signed then. And then on the 3rd of January 2019, it was filed. And I don't have any better idea than your lordships as to what filed really means, but at least the minutes say that it was filed. So those three things happened. In any case, and again, I think that my Lord Skim-Lewison picked up on this, it is not a ground for the failure to comply with a procedural agreement, if there had been one, is not a ground for annulment under the Code de Procédure Civile. It is different, by the way, from the model law, which obviously applies to international arbitrations, and which does, like Article 5 of the New York Convention, allow for annulment or objection to enforcement in the case of the New York Convention, where there has been a failure to follow the agreed procedure. In the case of Mauritian domestic arbitration law, there is no such ground for annulment on that basis. And the last point to make about these three conditions, is, of course, that this was not invoked by the respondent before the Supreme Court. Your lordships already have that, but just to be clear, we do object to this point being made now. Very last point, if I may, there was one of the last submissions made by Leonard Friend was in relation to the way that the signature had been carried through. And if I understood correctly, his point was that basically there had been the use of a template, which is why you find the same date being found there. In fact, if you look at the two awards, the unsigned award and then the signed award, if you look at the two signature pages, they are slightly different. So if you look at page 86 of the electronic bundle, you see that the date, this is the unsigned version, you see the date is above the signature of the arbitrator. And then if you turn on to page 101, which is the signed version, the signature page for the signed version, you find there that the date is below. So in fact, it's not quite right to say that it was simply a template that has simply been applied. But on that perhaps slightly technical point, my lords, unless you have any questions for me on my part of the case, on the primary case, I will hand over to learned friend Ms. Julienne.
Thank you.
My Lords, I'm going to address the point about whether there is any consequence of the arbitrator having been put out of cause, and the position of the appellant on this is that no, there is no adverse consequence. First, the filing of the application to annul. In the application to annul, it is the respondent itself who put the arbitrator into cause. There were lengthy written submissions filed by the correspondents accompanied by a bundle of authorities, and the submissions are at page 187 of the electronic bundle. There was a first hearing of the merits where...
Sorry, just give me that page again, please.
It's page 187.
Thank you.
There was a first hearing of the merits on 11th of June 2020, where the issue of prorogation was lengthily dealt with, including by respondent. And at this hearing, counsel for the correspondent moved that the arbitrator be put out of cause. This is at page 199. There was, at this point in time, no objection by Alphamix, stating that it had no objection if the respondent accepted that it be put out of cause. The respondent at this point in time did not take position. At the hearing, there were some discussions with the judge at page 216 of the electronic bundle, kind of halfway down. And there are some discussions here which are useful. The judge says, so you would be now taking the opportunity to move to be put out of cause. That's kind of in the middle of the hearing. And the counsel says, my ladies, let me put it in this way. It is too late for me to do anything. I'm there. I have already submitted. I'm just saying my friend may wish to take note of it and inform the court whether or not my client is a necessary party. And then this is a matter for consideration by the applicant, exactly, etc. And on the next page, at the top of that page, counsel says, I'm taking note of that, of what my friend is saying, but I will have to look into it. For the time being, I'm not prepared to put the respondent out of cause. And in fact, the hearing was completed with the correspondent still being a party in the case by way of email dated 25th of June 2020, which is at page 226. The respondent informed the court that it did not object to the correspondent being put out of cause. He was ultimately put out of cause at a hearing on 4th of February 2021. It was not a hearing at which there were substantive submissions. And this is at page 229, where he was put out of cause. There was one affidavit filed after that in the case, but it dealt mostly with the question of, it dealt with the question of public policy. It did not deal with prorogation. And then there was a final hearing on 18th of February 2012, and that is at page 239, but that dealt principally with the question of public policy. So the point I'm making is that, in fact, when the issue of prorogation was dealt with and submitted on, the correspondent was still a party. So there's absolutely no impact with the correspondent.
So once the arbitrator is put out of cause, does that mean the court doesn't have to deal with whatever submissions he may have made before that time?
In my submission, no. It is part of the record. So unless the respondent would have made a request to strike out, not to strike out, but to remove the evidence, to obliterate the evidence from the record, the evidence remains.
Well, it was submissions rather than...
The submissions remain, and they were before the court.
Yes.
Yes. So just one point. The correspondence submissions explain the reasons why Evidence was not brought by the arbitrator, and that is at page 188 of the electronic bundle. And it is stated at paragraph 3, pursuant to that principle, the arbitrator's award must speak for itself, and it is neither desirable nor permissible for the arbitrator to give evidence on the merits of his award or the underlying deliberative process. So there was case law that was put forward. So this is just a reference to explain the rationale behind that. Now moving on to the point
except that after the quotation, the submissions go on to say the court did not exclude the possibility an arbitrator may be called as a witness to enlighten the court on matters of procedure in the course of the arbitration. Then it goes on in the next paragraph to say the present submissions are made in order to set out uncontroverted matters of fact. And those seem to include the date on which the award was signed.
Well, there was no requests from the parties to give evidence. The arbitrator was not challenged on the date of the signature, and the position of the correspondent must have been, I suppose, at the time that was not necessary unless there was a specific request to it. So now moving on to the point that was made about the pattern as to the manner in which the arbitration agreement had been extended. It is denied that the pattern was in writing. It's exactly the contrary. There were 5 instances, and I have cited them, in which the extension was made by judicial contract. And there is no evidence that the agreement to extend...
Have you given us the references to those in your written case?
They are not in my written case. They are in my submissions. I will give them...
Could you please just give us the pages of those?
Yes,
and we'll
I will
look at them.
Looking for the document. I'll get to it. Okay, I've got them here. So the page is page 59.
Electronic bundle, page
Electronic
59.
bundle, page 64, 63 and 64, page 65, page 67. Yes.
I'm not sure for my part they're going to be of great assistance because we are dealing with the particular circumstances of this.
Yes, but I think what the respondent was trying to say in making reference to the written extension is that
we understand
there would have been some sort of formality, and that is not the case.
We have these page references. Are there particular matters you want to draw our attention to, or may we take it that it's apparent from those pages?
It's apparent from those pages that there was a judicial contract concluded to extend, and there is no evidence, contrary to what was stated by the respondent, that there was an agreement that was embodied in writing in a written instrument. Moving on now to the point that was made about the note 329 at page 823 regarding the mandate that was given to counsel and the distinction between avoué and avocat. The distinction between the two no longer exists in France nowadays, and in fact the note 329 itself refers to avocat, which is a reference to counsel. There has also a statement has been made in relation to the fact that the parties were present and the solicitor, the attorney. Not that it is relevant in our submission, but because counsel would have that authority anyway. But we draw the attention of the board to the fact that the parties and the attorneys were present on the 31st of December, and that is apparent from page 168. Just to finish on tacit prorogation, just a couple of words on this. The agreement has the tacit prorogation has 2 components. And this is to be found in paragraph 7.55(2) of our written case at page 411. Excuse me. So it has 2 components. and it is clearly stated in our case. The first component is a tacit prorogation, so it is a tacit agreement to extend the mandate, and separately, a tacit agreement to waive the potential irregularity that would arise out of the expiry. And why is this important? Because if for some reason the board were to find that there was no agreement to extend, because that there was no agreement to extend, then the agreement as regards the waiver could stand nonetheless. And in the alternative, my lords, that argument about waiver would stand in any case through unilateral waiver. And indeed, there has been a reference to the case of Raméchoir, and this, in our submission, represents the correct state of the law on unilateral waiver. And this is part of the written case, and the unilateral waiver is referred to in our case at paragraph 7.63, which
753.
763,
763,
which is
yes.
page 413 of the electronic
This is tacit prorogation.
This is, well, it's tacit prorogation, but the end of the paragraph is unilateral waiver. It's waiver. It is our case that the very fact that the respondent, so that's just on the facts about a point that was raised earlier, the very fact that the respondent requested a draft copy of the award at 13 hour in the afternoon on 31st December shows that the respondent did not expect the signed award to be communicated on the same day. Otherwise, why not wait for the signed award? And that, of course, goes to the intention of the parties to extend the mandate. Separately, the request to obtain a copy of the award while being content with receiving the signed award later on was clearly a waiver of the right of the respondent to rely on the expiry and more generally on any irregularity that would result out of the course of conduct adopted. As regard the point that was made about the conduct being post-expiry in the French cases, tacit prorogation does not require that the conduct necessarily has to postdate the expiry. Admittedly, most cases that we have seen deal with post-expiry, but this is potentially because the circumstances that we are faced with are exceptional, but there is no rules about the fact that the conduct that can be taken into account must necessarily be after the expiry.
What do you say about the point that it's got to be unequivocal or no room for doubt? The two of the formulations you've shown.
Well, this was the submissions that I made at the very beginning about the fact that the principle says that it's unequivocal, but the manner in which it applies is liberal. So there is some room. We don't agree that there is absolutely no room for doubt. And by definition, if we're looking at conduct, by definition, we might not be looking at something that is always extremely clear as to the intention of the party having the course of action. My last point is about equity. The counsel for respondent has stated that the appellant was asking for equitable remedies. The appellant is not asking for equitable remedies. Article 1135 of the Civil Code that the appellant is relying on is not an article of, well, it is not a provision of the law that is about equitable remedies. It is part of the set of rules of interpretation of contract under Mauritius law, and in fact they are the same as the French rules of interpretation prior to the 2016 reform. And this article is an article, this provision ultimately gives the powers to the court to imply into a contract an implied term by reference to considerations of equity. There is no provision in the Civil Code or anywhere else in Mauritius that provides for implied term. And this is the legal route that comes the closest to the equivalent of implied term in English law. And in my submission, Article 1135 is quite clear as to what the arbitrators have the powers to do, or the court. Unless I can be of assistance, I have no further submissions.
We are all most grateful to you for your submissions, both in writing and made to us today in the course of your oral submissions. The board will consider all of them with great care, and we will give you our decision as soon as we possibly can in the usual way. There is one outstanding matter, which is the undertaking that you have given to us that you will look at the translation that you have and let us have any, or endeavour to agree it, and let us know if there is any dispute about any particular aspect of the translation. That is not an invitation to refer us to further cases. It is simply to do with translation itself.
We have agreed on the case law already, translation, or the interpretation of the translation. It's not a pure translation. It's what the gist of what is meant. It is in English, but what we have to do now is to look at what has been translated and sent to us a couple of days back, and we will, if ever we dispute something or we disagree with something, we will communicate with your registry.
And we would ask you to agree between you as to when that will be provided. Obviously, you will endeavour to agree the translation, but in any event, it should be provided to us as soon as possible.
Certainly.
And we would ask you to let us have your response within a week.
Great.
Thank you very much indeed.
Thank you.